For this luncheon session, I have the privilege of introducing Dr. Michelle Mello. Dr. Mello is a professor of law at Stanford Law School and a professor of health research and policy at Stanford University School of Medicine. She conducts empirical research into issues at the intersection of law, ethics, and health policy. She is the author of more than 160 articles and book chapters on the medical malpractice system, medical errors and patient safety, public health law, pharmaceuticals, research ethics, obesity policy, and other topics. The recipient of a number of awards for her research, she was elected to the National Academy of Medicine, formerly called the Institute of Medicine, at the tender age of 40 years old. From 2000 and 2014, Dr. Mello served as a professor at the Harvard School of Public Health, where she directed the school's program in law and public health. Dr. Mello also teaches courses in torts and public health law. She holds a JD from the Yale Law School, a PhD in health policy and administration from the University of North Carolina, Chapel Hill, and an MPhil, Master's of Philosophy, from Oxford University, where she was a Marshall Scholar, and a BA from Stanford University. Please help me in welcoming Dr. Michelle Mello.
It's a real pleasure to be here. I really enjoyed this morning's sessions as well, and I think we heard some very powerful stories about Candor programs. And in many ways, I think those stories, narratives of how people's lives were transformed by this approach, are the most important information that you could take away from a program like today's. But it's been my experience in working with many different hospital systems over the years on this approach that at some point, somebody says in a board meeting or a physician education session, show me the data. I want to know that doing the right thing is not going to bankrupt my organization. And so that has been a project for me over the last 6 or 7 years to try to understand a little bit about how these programs affect the bottom line within hospitals in terms of liability costs, how they affect patients' and providers' experiences, and what it means for the institution to go through a process of implementing these programs. And so I was asked to come here today and share some information about that with you. I'll begin with a disclosure that one of the programs I'm going to talk about from Stanford University, the Summit or the Risk Authorities program, that comes from an organization that has funded some of my research on unrelated topics. So take that for what you will. As you've heard, there has just been enormous interest in the Candor approach over the last 10 years, largely springing from very compelling anecdotes about institutions such as University of Michigan, University of Illinois, that have reportedly experienced improvements in their liability costs that are just nothing short of astonishing. You know, as somebody who spent quite a bit of time studying public law reforms to the liability system like damages caps, I am here to tell you that the reductions in claims and costs that have been reported by some of these early Candor adopters are literally an order of magnitude better, greater than anything that we've been able to achieve with a public law reform like damages caps. And so naturally, there's a lot of interest in getting a piece of that for oneself. So these anecdotes, I think, have really propelled interest in scaling up this approach. And so we have seen a very rapid scale up, as Dr. McDonald was talking about this morning. He's now working with literally dozens of different institutions nationally. And there's been a lot of support for that scale up from the Agency for Healthcare Research and Quality, as we've heard. There has emerged, however, in some quarters, some skepticism about whether this field is moving too fast, and in particular, how can it be that programs like this produce reductions in liability costs? Because anybody who knows anything about the epidemiology of medical injuries and malpractice claims knows, and you all know from your daily experience, that for every lawsuit out there are 50 patients who are injured by negligence who don't sue. There is a huge reservoir of unlitigated negligence out there. And so it's reasonable to ask, why would this approach save money? And if it is saving money, are hospitals really doing what they say they're doing? So part of my research has been investigating those questions. And over time, I've moved from a really kind of an open skeptic of this approach to a believer that when it is done right, it really does work well. but also that doing it right requires a lot of attention to detail. And so I hope that some of what I'll share with you today gives you some ideas about how to not just do this approach, but really to do it right in a way that can bring some of the benefits that the early adopters experienced back to your own institutions. The spread of this type of approach has moved rapidly from a number of early adopters, and you've heard from one of them this morning, to a bunch of other institutions that were supported in formal demonstration projects by the federal government, as I alluded to earlier. So we learned quite a lot pretty quickly from looking at these very pre-planned and robustly evaluated demonstration projects. Even while these were still going on, though, the government moved ahead with scaling this approach up for national dissemination. So there are lots of new adopters on the horizon. We don't really know yet much about outcomes in those institutions, but I can share some data from a number of institutions that were over in this category of the second wave. Let me start with the one that you probably heard the most about, which is the University of Michigan. One of the things that was remarkable about this university is that they did evaluate their program in a very robust and very public way. So this paper is published in the Annals of Internal Medicine. Not an easy place to get a paper into, I can attest. And it's a pretty well done evaluation that looks at the institution's experience before and after it adopted its own version of a Candor program. And again, these results here are just remarkable from the perspective of somebody who studies what works in medical liability. Just huge reductions in the number of new claims every month, as well as in the time to resolution. And note, this institution was already super quick to start with. They still got a significant decrease in their time to resolution. And big reductions in the amounts that they were paying per claim in patient compensation costs, largely attributable, as the institution narrates it, to just sort of getting to yes more quickly and not inflating the value of a case by dragging it out. Finally, and I think this is in many ways the result that they're most proud of, they were able to decrease the amount that they spend on defense costs very dramatically by not defending the indefensible. We recently had published a follow-on study from the University of Illinois. This is the one that Dr. McDonald and Dr. Lambert referred to this morning. This is their paper in Health Services Research last December. And as they alluded to this morning, this institution too experienced some statistically significant and rather impressive improvements in its liability profile because of the program. As a threshold matter, it's interesting to note that the program had its intended effect of getting more incident reports in the door, having more patient consultations going on. So any reductions that we see down here are not because there was less injuries in the hospital, unfortunately. But what we do see is big reductions, all statistically significant in these key variables. And this is in an analysis that looked at what the trend line looked like before and what it looked like after, and was able to compare this institution to 43 other hospitals in Cook County. And what was remarkable is overall, at this hospital, all of this stuff was getting worse for the most part before the intervention was adopted in 2006. And then after adoption, most of them got significantly better. There were a couple of areas where we didn't see big differences in terms of that trend, trend changing. This is the number of overall lawsuits. I wouldn't put too much stock in that because, as you know, a lot of the action is upstream in terms of claims that don't eventually become full-blown lawsuits. Settlement amounts per claim, interestingly, didn't change. So what we see here in terms of overall reductions in costs is most likely driven by fewer claims and lawsuits rather than paying patients less in each one. That's different from what Michigan experienced. And then finally, time to closure. The trend line was not significantly different after the event, but it had been going down before and it continued to go down. So again, another really impressive set of results. At my institution, Stanford, we don't have a peer-reviewed publication like this, so we have to take information that they give us, I think, with a little bit of a grain of salt. These data come from Stanford's independent actuary, and again, they report really huge reductions in the volume and cost of liability claims, and again, also a significant reduction in defense costs for cases that were handled through their Candor program, which they call Pearl. So these are very impressive. Again, if I was a hospital administrator, I would want this for my hospital just based on this series of results. But they are anecdotes, and we want to build the evidence base a little bit more. So over the last several years, I've been involved in an evaluation in Massachusetts that has been seeking to add to what we know, and really to get into questions of how this gets achieved and what does it take to replicate these results. So let me share some of those projects with you. I want to focus on Massachusetts, but let me tell you about a couple of others first. We did two projects under the federal government's aegis, one in New York and one in Washington State, where we were trying to replicate what had gone on in earlier institutions. And to make a long story short, we didn't. So these two studies, I think, really serve as a cautionary tale about how difficult it actually can be to do this approach right. The first study was in New York City. We worked with 5 hospitals. This program was brought to them by the New York State Department of Health, which partnered with the hospitals, but which also regulates them. They're the ones that give out licenses to hospitals. And what we found there is that the hospitals were really successful in improving their disclosure practices, their communication policies and procedures, their care for the caregiver programs. All of that went really, really well. What didn't go so well was the compensation side. So I said that a lot of skeptics question how these programs can achieve big reductions in costs, given that there's so many events out there that we should be compensating. And the answer is, in this case, they compensated the slam dunks. You know, there was a lot of enthusiasm for paying quickly on cases they knew they were going to pay on anyway. What was a lot harder were cases where there were question marks. You know, it was a gray area as to whether an error had occurred, or the disclosure conversation went so well, nobody was asking for money. And the risk managers couldn't be persuaded that they ought to be the first one to bring that up. What complicated this further is that their liability insurer, for most of the hospitals, was a commercial insurer that was distant from the point of care. So they did not have boots on the ground, they didn't see the patients, and they did not have the same ethic, I think, around compensation that the risk managers who saw these patients frequently did. And so the result was, in these gray cases, a lot of times compensation wasn't offered. We did a lot of work trying to understand why implementation wasn't as complete in these hospitals as we would have liked. And I think a couple of issues really rose to the fore. I think the chief one was that because this program was brought to them from outside, the buy-in from top leadership within the hospital was lukewarm. They had it in principle, but they didn't have it in practice in terms of having a highly visible leader out there championing the program and saying, this is what we are doing now. And so as a result, it was a constant struggle to maintain visibility, to engage the clinical staff, and to stay principled about offering compensation in every case. And the other factor, which will be familiar to all of you, is just workload and overwhelm. Trying to innovate and change the culture in an environment where these hospitals were facing not just an avalanche of risk management tasks, but electronic medical record changes and inspections and a barrage of new other patient safety initiatives really, really proved very difficult. And so I think underscored to me that this program is not free in terms of administrative costs. It takes work. And again, if there's not the commitment to doing that work, it's likely to founder. The other project I mentioned was in Washington. The innovation here was that we were trying to get institutions to work together to resolve cases that involved both a hospital and a physician who had separate insurance. So the physician was not insured by the hospital, they were insured by a separate entity. And long story short here, that's really hard. So we had some entities that really, really wanted to play and were deeply committed to the approach. Other entities were more hesitant. And in a lot of cases, instead of being cooperative at the Candor table, there would be blame shifting, finger pointing, or just a reticence to really be the first person to step forward. Everybody was waiting for the other. There were also practical barriers. Again, when you're dealing with insurance companies that are not inside the health and care institution, it's much harder for them to execute this approach. They're not there, they don't have immediate access to the medical records, and a simple but important barrier in a lot of these cases was they couldn't get it. The hospital had trouble getting the patient's authorization to release these records, and so the delays would stretch for weeks or months, and people would kind of lose their nerve. So we had some successes in this program, but it really underscored for me that doing this in a hospital is relatively easy compared to doing it in a bunch of multi-specialty physician clinics or in settings where you have different insurance companies at the table who really do have to both agree, we're going to be committed to this approach, we're going to do it together. The study I want to focus on in the balance of my remarks today is the one that we've completed most recently in Massachusetts. And it involved two big medical centers, one of the Harvard-affiliated teaching hospitals, the Beth Israel Deaconess, and Bay State Medical Center, which is a big academic medical center in the more rural western part of our state, as well as two of their small community hospitals. This was not one of the projects that was supported by the federal government. It was actually funded by a coalition of insurers and hospital systems. So this project aimed to implement the Candor approach and test it in these settings. And we really aimed to answer 4 questions in the evaluation that was kind of baked into this experiment. And I'll go through each of these today. But note that one of them is really focused on, did they do what they said they were going to do? In designing and implementing this intervention, we started, I think, by learning from what had come before, both the programs that were really successful and then projects that were less successful. And one of the things that was really important at the founding of this program was recognizing that the program is more likely to be successful if it's the product of a multi-stakeholder consensus-building process and it has the support of top leadership. So we had a team here that brought together the 2 hospitals, some external academic evaluators, and then this organization that was created called Macrame, which is a broad coalition of really, as you can see, a wide group of stakeholders. And note that involved in this coalition is the plaintiff's bar. And that really proved very important in making sure that this program was trustworthy and adequately protected patients' rights. And I think that was critical to its success. So this group advised and supported the hospitals every step of the way. They met frequently, they troubleshooted ideas, they came up with the intervention together, and they met at least twice a year in a large group to evaluate how things were going. We also learned, as I stated before, that this process had to be led from within the hospital. It couldn't be imposed by me or others on the outside. And so really, from the beginning, the project was supported by very high-level leaders at the EVP level at 2 of these major academic medical centers. We also felt it was really important to evaluate as we went, but that had to be at arm's length, and that's why I was involved in the project. And we learned from the New York study that this thing was not going to work unless there was somebody whose job it was to make sure that it worked. And so I think it was really critical in this project. The project paid for a full-time project manager in each of the 2 hospital systems, again, who worked on this more or less full-time. The protocol for this program is pretty similar to what you've seen. I'll just go through it quickly. The key thing to note here is that there's 2 levels of determination. An initial determination is made within the hospital. Is this an event that we think is potentially compensable? And these are the criteria here. If so, it gets referred on to the insurer, and the insurer will make its own determination using what the hospital concluded, but again, reaching its own independent determination. And then following that, the goal is to have a feedback conversation with each patient or family about their investigation result and the resolution determination, whether it's positive or negative, and for events that go completely through to the insurer to do a pretty robust patient safety analysis for lessons learned. So in terms of what happened, we learned about that through collecting a variety of kinds of data. I'm just going to focus on a couple of these projects now. What's important to know is that over 3 years, we had almost 1,000 events go through the program at the 4 hospitals that participated in the study. We also instituted a survey of clinicians who had a case go through the program. These were overwhelmingly physicians with a few nurses. That was just in the 3rd year of the study. So what did we learn? Well, I think to understand those results, it's useful to know what kind of events we're talking about. And the key thing to note about this program is that they made a decision pretty early on to focus on relatively serious events. So to get into our study, your event had to have resulted in at least 3 outpatient visits or an invasive procedure, or obviously it'd be of greater severity. And that also was a lesson learned from the New York study, where they tried to do this for all events and were just overwhelmed by the number of low severity, low harm events that still had to be investigated. So in terms of what the sample that I'm about to talk about looked like, it was about 1/4 permanent harm events, about 1/2 of events that resulted in a significant harm that was temporary in nature, but a sizable proportion still were lower severity events that got in for reasons other than their severity. These are mostly going to be cases from the two big academic medical centers that I'm talking about. They were mostly reported by people internal to the hospital, not attorneys or patients, which is what we were hoping for. They mostly involved attending physicians and occasionally nurses, and they really ran the gamut in terms of clinical areas, but surgical events were pretty prominently represented in the sample. About a third of the events were surgical events. Okay, so the first question we ask is, did hospitals do what they set out to do? And to measure this, we made them keep detailed records on the progress of every case through their system in a database that we set up. So every time they made a move on the case, they had to record exactly what happened. And the results were pretty good here. They pretty much did what they said they were going to do. So the first thing they were supposed to do is have this disclosure communication. That was documented in about 80% of the cases, and we looked at each and every case where it wasn't. Overwhelmingly, these were cases that the hospital didn't know about, so they were the ones that were brought in to their attention by the patient, for example, or there were things that happened after discharge. They were very, very, very rare that the hospital did not deliver disclosure where it should have. The rates of the feedback conversations after the investigation were lower. But again, when we looked at these, most of the time there was a reasonable explanation. The most common explanation was that in the initial disclosure conversation, they conveyed everything that was known. There actually wasn't that much more to learn about the event, and so there wasn't any additional information to be conveyed. But often there actually were patient-related factors that made it hard to execute on this feedback communication, like they just didn't want to talk. I'll talk more about that in just a second. But this was one area where I was a little bit less happy with the results than I could have been. There were about 100 cases where they didn't document a reason for not holding these conversations. And when we talked to them, they talked about a number of challenges, but bottom line, this was something they could have executed on a little bit better. 87% of the cases that the hospital said, yep, this looks like something the insurer is going to want to compensate, actually got referred on to the insurer, which was good, pretty high. And again, most of the time when that didn't happen, there was a reason, and almost always it was related to the patient not releasing medical records or saying, I don't want my case evaluated. And then compensation offers were made where they should have been made in all but 3 cases. So much different situation from the New York hospitals where they did it about 1 out of every 6 times they should have. Almost always they delivered here, and the 3 cases were cases where the risk manager said the family seemed satisfied, which is a difficult area. We, I think in retrospect, concluded it would have been better to move forward in those 3 cases as well. So I said that patient-related factors could sometimes pose a barrier to carrying this stuff out. Let me give you a sense of what that looked like. Often hospitals would repeatedly phone people after they had left the hospital and they would not get the calls returned, or they would be told, stop calling me, I want to move on. So this would typically happen in cases where the severity of the injury was more moderate, it had resolved for the patient, and they really were just looking to move on with their lives. Others were angry though, particularly those who got this feedback communication with the hospital, and the feedback was, we didn't error here. There was no negligence. Standard of care was met. They're too angry. They don't want to engage after that point. Not releasing medical records, again, was a major barrier in this project. And then a few families just didn't want to go down this road at all. They didn't feel that they needed compensation. I think that was actually an important finding, because there are families for whom compensation is not necessary. And there are a few families in our sample who said that it was offensive to them to have an offer of compensation for an event that they felt that the offer of compensation sort of cheapened what had happened. And these were often cases involving children. Where they said, you can't put a price on my child. I don't want to talk about money. I want to know what you're going to do to prevent this from happening again, for example. And then in a few cases, attorneys stood in the way. There are many attorneys in Boston who work well with the hospitals on this approach. Some don't. They prefer traditional litigation. We did, I think, identify safety improvements in a fairly large proportion of the events for which this was done, which is, again, just those that went to the insurer for possible compensation. We didn't try to look for safety improvements in the unpreventable events. About 4 in 10 of those led to a safety improvement being identified. So these are just some examples of the things that were implemented as a result of these cases. And, it's not like the hospital wasn't looking at interventions like this before, but what this program did was routinize the process of looking in every case and asking the question of what can we learn. And often the answer is, there's not a safety intervention, but there's still something that can be learned about communication. Yet, in a large proportion of cases, there actually was something to be learned about patient safety. There we go. Okay, so what did this all cost? The good news here is not much. And the reason is that very few of these events actually qualify for compensation. Again, the way they get compensated is if there's a standard of care violation, it caused harm, and the harm was significant. It was above that required 3 outpatient visits or more. So the criteria were intended to mirror more or less what goes on in the tort system. This was not a program like University of Michigan where the standard is we could have done better or it didn't live up to our standards. This is more or less the legal standard of care. So when all is said and done, 9% of the events in this program met those criteria. So as a researcher, my first question is this bogus? Should we believe these data? Because the people evaluating these events, of course, have an incentive to conclude that they don't meet the compensation criteria. But when I look at this, for example, standard of care met 74% of the time. Well, that is almost precisely consistent with 2 previously done large chart review studies of medical injuries that we did at Harvard. 3/4 of events are not preventable, 1/4 are. So that actually was pretty reassuring. It seems real to me. Where the standard of care was violated, 45% of the time we didn't have significant harm. So the decisions you make about severity thresholds in programs like this are really going to impact your bottom line. If all those lower severity events were in there, it would be a lot higher than 9%. And then 33% of the cases, they found no causation between the event and the injury. So patient got an infection in the ICU, the patient died, but he didn't die because of the infection. It's harder to assess the realness of that number. We don't actually have a lot of comparable data. But given that they found causation 2/3 of the time, I'm inclined not to think this was like a lot of reviewer bias in play. Most of their judgments were not favorable to the institution. The median payment for these events was not super high, $75,000. The 25th percentile, about $22,000. The 75th percentile, $250,000. A few big payments, including a $2 million payment in there. But mostly because, again, thinking back to the severity of these events, about 1/2 of them are temporary significant harms. These are not break the bank type of cases. Additionally, the hospital stepped forward with service recovery offers in 181 cases. These were almost all cases that weren't eligible for compensation. There were a few cases where they gave money and service recovery items, but it wasn't used as a substitute for money. So these were things like parking vouchers and meal vouchers and gift cards, and most importantly, waivers of medical bills, as Dr. McDonald talked about this morning, really important as if nothing else, a means of showing that you have your act together as an institution. So overall, I think the study showed that predictions that these kinds of programs would result in an avalanche of new claims just were not borne out. When we looked at how many of these events had progressed to a claim or a lawsuit, by August 2016, the number is about 5%. Now, we had a little censoring problem in our data, meaning that there's some people out there who could still file at the time that we closed our study. But when we compared the events for which the statute of limitations had already run and those that it didn't, actually the proportions weren't much different. So for the events that were closed out, I think that number was 6.8%. So we may still see a few more claims in this sample, but it's probably not going to exceed 6 or 7% going to litigation. So why is this? I mean, it's hard to know as a researcher. The sunny explanation is that people got the information they needed to understand that they did not have a claim. And so they didn't file a claim. The skeptic's explanation is that, smooth-talking mediators convinced people they didn't have a claim when they might have. And, I take that critique from the plaintiff's bar seriously. It's already really difficult to get a plaintiff's attorney, particularly in Boston. And when you have to go to an attorney and say, the hospital looked into this, they sat down with me, they told me everything that happened, they showed me all their records, and they told me that it wasn't an error, you're going to have an even more difficult time finding an attorney. So what that underscores to me is really the importance of good faith and due diligence in these conversations with patients, because it's very easy to chill people who really belong in the legal system if this is not done right and in good faith. Let me talk a little bit about how clinicians felt about this program. We had two key findings here. One, a lot of people didn't know what it was. And two, the people who knew what it was really liked it. I will say that these hospitals went to extraordinary lengths to educate their clinical staff about this program. It was like several dozen different presentations to departments. There was a website, just inordinate amounts of energy spent educating physicians. But still, when we went back to the physicians who had an event go through the program and asked them, what'd you think of the CARE program? Nearly 40% of them said, what CARE program? So they would go through the survey. At the end of the survey, one physician wrote, great idea, too bad it's kept a secret. So what happened here, my own sense is that it had a lot to do with how risk managers talked to clinicians when they had an event go through the program. Unless that event got all the way to the stage of being referred to the insurer, they didn't call the program by name. They didn't call it a CARE event. They didn't say, I'm calling from the CARE program. They never branded it. And so to the physician, it was just another call from risk management. They never had the sense that they were being routed into a program, and they didn't identify the risk management part of things with other things like care for the caregiver that were available at their institution. So the importance of packaging this and branding this to the clinical staff and making it visible, I think, is really underscored by these results. The other thing is that the clinicians who really understood what this program was reported very positive feelings about it. And there's some negatives in here. These grays are the negatives. But in the context of a program whose purpose is to give away a lot of money against physicians, I actually think these negatives are pretty low. There are many physicians who would prefer to take their chances in the traditional litigation system because they know those chances are very good. So the fact that you have this many people reporting strongly positive views, or at least moderately positive views of the program, when the program is in the business of sort of admitting error on their part, and offering money, I think is fairly remarkable. And I think the best results are down here in terms of how fairly did this program treat you and treat the patient that you hurt. These, to me, are the most important results. And overall, sort of at the bottom line here, you can see, again, most clinicians who know about this program really, really support it. And in their free text comments, they wrote in over and over and over again, you need to communicate better about it, but this really supports me in doing the right thing. It helps me do what I want to do in the aftermath of an adverse event. Finally, what do we learn in Massachusetts about how to do this approach right? I consider Massachusetts to be a success in terms of implementation, in contradistinction to some of the other projects that I've been involved in. So what made the difference there? My sense that there were several factors were in play, but certainly the highly visible, highly regarded, highly placed clinical leadership was at the forefront of the things that really made a difference in these institutions. So again, executive vice president, chief medical officer, these are the types of people that need to be out front. We also had really, really strong buy-in from the on-the-ground risk managers who had the day-to-day task of doing the program. And again, that hasn't always been the case when we've gone and tried to do these programs because it adds to workload. But these risk managers really believed it was the right thing to do, and they were supported in their work by the full-time project managers that we supplied. So they were able to handle the workload, and they really, really executed and did so with enthusiasm. It also helped that the insurers just stayed out of the way. There was some initial skepticism by one of our insurers about what this was all going to mean for their bottom line. But after the first few months, they really just stepped back and let the program unfold. They let hospitals run it. They went along with protocol. And again, this has not always occurred. In other cases, the insurers have not wanted to play as much as the hospitals, and that's a problem. The people who are writing the checks have to be bought in fully for it to work. Both of these medical centers had a pre-existing culture of disclosure and apology. They had those policies in place. People were already bought into that aspect of the program, and so this really just built an architecture around it. And a lot of people that we interviewed said that that was really critical to the success of the program. They didn't have to fight clinicians on that front. And then finally, everybody reported that having this group called Macrame behind them in the effort had been super, super helpful. And we actually heard this from the New York hospitals as well, that when they got together to talk about their progress, they felt well supported. It was very valuable. They learned things. They came up with solutions. And they had that emotional support when they were taking risks for themselves and the institution. Our processes were even more robust for providing that support in Massachusetts. And it really, really mattered to these hospitals. It made a difference. And it made a difference to them that they had input from patient groups, from the trial bar. Everybody was at the table really helping them succeed in what they were doing and making them feel like they weren't in it alone. So I really advised the building of work groups across institutions. So to wrap up, despite concerns that these programs may cause the sky to fall, that's just not what we have seen. In the best case scenario, it saves lots of money. In the worst case scenario, it enables institutions to do the right thing without costing them more. And that, to me, is also a win. I think it's also important to realize that although all of our focus in these conversations and narratives about these programs is about patients who are harmed by medical errors, the bread and butter of these types of programs is non-error events. 3/4 of the time, you're going to be dealing with an event that just happened. And what the patient needs is not money. They need information, an appropriate apology of sympathy, and so on. But you're not going to be giving away money. And so I just think it's important to think about that, both as you assess the potential cost to the institution and how much work would be spent on an individual case, that it's really the minority of cases that have to be fully worked up and compensated. When you do offer compensation, typically we're not talking about huge awards. They should basically reflect what a patient would get in the tort system. But because in these programs, more moderate severity events get in than would be the case in tort, on average, the awards should go down. So let me say that again. You know that it's really hard to get a plaintiff's attorney and sue in tort unless you have a high severity event worth lots of damages. This process is meant to be more inclusive of people who have lower severity events, so lower damages on average should be expected in the program. See if I can do it from over here. Oh, there we go. Right, and then providers, as I say, if they know about it, they like it. The challenge is getting them to know about it. And the recommendation here, I think, is that although you have to do a lot of outreach at the beginning, you want to have a big launch and so forth, it doesn't become salient to the provider until something happens to them. That's when they need to be told, hey, remember there's this program, it's available to you, and here's what we can do for you. One thing that I think actually helped quite a bit in Massachusetts was a legal innovation. This broad coalition of stakeholders went to the state legislature before they started all this and got a law passed. Some aspects were similar to your law here in Iowa, but one thing that they added was a cooling off period, which means that before a patient can formally file a lawsuit, they have to give the hospital 180 days notice that they're going to do so. And that creates an opportunity for this early intervention to take place in cases that weren't on the hospital's radar screen before. So it was a minority of cases that came into our sample because a pre-litigation notice was received, but this was really an innovation that gave the hospital an opportunity to avert disaster by getting in early on a claim that was already lawyered up. I think one caveat that I would take out of this body of research is that we've learned quite a bit about how to do this in large hospitals, but we still don't really know how to do it in smaller facilities and especially in non-hospital settings. I think because of the workload that's involved and just the meticulousness of making sure that all the aspects of this process are adhered to, it can be difficult in places that don't have a well-staffed risk management department. And finally, we really had great implementation fidelity, as I said, in Massachusetts, which was much higher than in other places. And this really goes to the point that I started with, that it's easy to implement these programs, it's hard to implement them well. And so it's really about how you achieve that if you want to replicate the results of the earlier adopters. Just in closing, I was looking for study guides for my students the other day, and I came across this great book on Amazon called How to Avoid Huge Ships. And it really reminded me of the risk management challenge, how to avoid huge lawsuits. In many respects, the answer is obvious. You treat people like human beings, you meet their human needs, and then you get out of the way. But it actually requires some skill, just like avoiding huge ships. Big ships are hard to turn, right? Small maneuvers by the captain can have really big consequences, and the waters are always shifting around in unpredictable ways. So I think this is a story of Candor implementation, that really the devil is in the details in terms of implementation. The good news is we've learned a lot about how to do this right. And I think when it's done right, it is a very, very powerful way to avoid huge ships. So I'll close just with this quotation from one of our clinicians in the Massachusetts project, and this screenshot from one of the videos that's available from the AHRQ Candor Toolkit that Dr. McDonald talked about in the this morning. You can't see this, but there are some other resources available online from Macrame, as well as the Collaborative for Accountability. So really, at this point, lots of stuff available to help you get started and to learn from those who have come before you, who I think have a lot to offer in terms of learnings. So I'll stop there. I'm very happy to take your questions. Yes, sir.
So, have you had any models in which you have successfully integrated an insurance carrier into the process? You made a couple of comments, I'm paraphrasing. You said, one was you went through the process and you had the insurer write the check. And then another one, I think you said, the insurer held back and inspected the process and let it work. There are a lot of carriers that have a lot of resources in patient safety and risk management and communication. So we're really interested in how these models might integrate with each other. Did you ever have a model that was successful in integrating the carrier into the process?
Yeah, it's a great question. I mean, I think that was one of the aspects of the Washington project that was most successful. That project was actually co-led by Physicians Insurance, which just insures independent physicians. They insure a few hospitals, but not many. So what was successful about that was that they helped lead the design of the intervention, and they made sure that as an external insurer, they were prepared to cooperate with the hospitals. In practice, the cooperation didn't go that well, and part of it had to do with some water under the bridge in terms of prior relationships and trust and so forth. But I think that was an example of an insurer who really jumped in and was fully committed to the process. With the hospitals, they were very involved in the design of the intervention, but then, as I say, kind of sat back and waited for hospitals to bring it to them. There's certainly more they could have done to market it to physicians. Premium discounts, the insurer in Boston that we work with has offered premium discounts for other things like obstetrical training that have had huge uptake. So it's clear that their subscribers really value that type of incentive. So I think there's lots more that could be done by insurers to kind of get these things off the ground. But I must say we were happy that they just didn't hold the program back, which has been the experience in some settings. Yes?
Earl? Here, use the microphone.
I found it interesting that in one of the coalitions and consortiums that was developed, that state agency that a licensure,
Yes, the New York State
agency
Department of Health,
was involved.
Yeah.
Okay, and just wondering what their contribution was and why they were invited to this. Were there questions about how this program would impact or influence, let's say, complaints called in to the disciplinary or regulatory agency?
Yeah, so they actually led the project. They were the ones that got the grant, and this was just something that they really wanted to try as a patient safety measure. So it was from the patient safety folks within the department that the initiative came. But they didn't really have an axe to grind as a regulator per se. They just saw this as an extension of their patient safety mission. But it's really, really hard to explain that to a hospital that has a visitor from the Department of Health coming through every month. Hey, how's it going? How's my program working? Are you guys fully bought in? That's hard. Much, much better when it's your own CMO promoting the program.
Other question that I have is, how would this program impact, let's say, if a complaint was called in because of what was thought or perceived as patient was harmed, to, let's say, a state agency that disciplines the physician and non-physician providers?
Yeah.
Would this be discoverable? Is the confidentiality
So I'll give you the lawyer's answers, which is it varies from state to state. But there are ways to design these processes to keep them out of discoverability and within the peer review privilege. Some institutions choose not to do that. Their position is, our point is this is about transparency. So to do all this behind a cloak of privilege is not consistent with the mission of the program. So I think it's variable as to the legal status of the initiatives. There are other ways, though, that I find even more interesting in thinking about how they interact with disciplinary processes. And one of the most interesting things is to think about partnerships with boards of medicine that recognize that when a hospital has adopted a policy like this and is doing it well, the presumption should be no discipline in one of these cases. So there has been now a successful pilot in Washington State of what they call a CRP certification process for communication and resolution programs, that a hospital can submit an event to the medical board, say, we've got this program, we have investigated this event, here's all the steps we've taken, we've instituted these corrective actions, or we have found such and such, no responsibility on the part of the physician. We want you to certify as a board that this is likely not going to be the subject of disciplinary action. So they have been able to work that out with the board in its early days, but the hope is that this will provide an additional incentive for physicians to want to participate robustly in this process if they know that an alternative to formal discipline, which in Washington State is incredibly punitive, is to go through a gentler process within the institution. Yes? Here in the
I was actually going to answer that question too. We did have one of our cases who called Joint Commission to file a complaint. And actually, because of talking about the process that we went through, they chose to just have us send them a little summary of this, and it went away quickly because we went through this process and didn't hide it from them.
Yes.
Thanks, Michelle, for summarizing all that. It's really interesting to hear about the Massachusetts results. I hadn't heard those before. There isn't an official kind of patient representative at this meeting today, so I wanted to say a couple things from that point of view. When these sort of founding principles of Candor, when I learned them, were mostly patient-centered things. They weren't about protecting either institutions or providers. They were mostly about justice for patients and families in terms of that patients and families deserve to get the truth about what happened. They deserve to get rapid resolution without litigation, especially if the care was really indefensible. These are the kinds of guiding principles that we learned from Rick Boothman and others, and that we tried to embody at University of Illinois. So there's a couple of implications. One is about these events that didn't meet the standard for compensation. And I can definitely see how, from the point of view of the institution, those look like a win. It's like, well, we're not going to pay out any money. If you're an insurance company, that looks like a win. From the point of view of this principle of justice for patients, it doesn't look like a win. The idea motivated by justice is when a patient is harmed, they ought to receive some sort of fair compensation from the person that harmed them. And we found, we didn't publish this part because the data weren't clean enough, but the vast majority of, when we made a financial compensation to a patient or family, I think the most common value was below $5,000. It's just like we did many either waiving of the bills and charges or small amounts of compensation. So I think that's one. It's not necessarily a principled victory when you don't pay the patient or family if they've been harmed. And the second has to do with a trend that I've seen around the country, including a little bit of what I've learned about at Iowa, and I don't claim to be an expert of what your law is here. And that is that these Candor approaches, which were initially designed to really protect and serve patients and families, a lot of the laws protect and serve clinicians and institutions. So a lot of these so-called Candor laws are about making things more private, protecting more things from disclosure, extending confidentiality to more procedures. And there's at least some pushback on the parts of patient advocacy organizations and others, and some of the plaintiffs' bar too, about that this is a perversion of what Candor was. That's not exactly my view, but I wonder if you could comment on that trend.
Yeah, I mean, that's not a complaint I've heard a lot from the plaintiffs' bar, but I do take the point, as I said earlier, that it seems inconsistent with a commitment to transparency to cloak this process in privilege. I fully understand why the opposite perspective is you will not get physicians to the table unless you do that. But I take the critique. And hopefully in most cases it proves unnecessary to designate this as privilege because there's no follow-on. Again, 19 times out of 20 there's not going to be a legal dispute to try to protect it in. I think your point about the money is well taken. Having said that, my experience is when you're talking to patients who have had it explained to them that they were harmed in an unpreventable way or in a way that was not due to error, they're not thinking money in most cases. So we interviewed, 92 patients from these Boston programs, from the Stanford program, and from New Zealand, which operates an administrative compensation system for medical injury, and asked them about their reactions to how the hospital had treated them after the injury and what was important to them. And overwhelmingly, particularly for people who didn't have permanent disabling injuries, they talked about the importance of just being heard and having that acceptance of responsibility on the part of the hospital, having an opportunity to physically confront the provider. They didn't use the word confront, but they wanted the doctor in the room with them to face them and make him listen without taking notes and without interrupting, just to let them narrate their story, notwithstanding the nail in the head. That's really the message that I took away about what is most important to provide to those patients. Now, having said that, when we're angry, we all appreciate it when we get comped stuff, so I don't see any reason not to do that, if that helps. But I have a feeling that what made the difference to these patients was not the free cafeteria meal, but really receiving an authentic opportunity to be heard. And that, as you well know, is a much harder thing to do than do the United Airlines $50 voucher. Yeah. Okay.
Any more questions? Well, again, we want to
Thank
thank
you.
Dr. Mello
Thank you.
for her presentation.
Thanks very much for having us.
We wish her safe travels.